Legal provisions related to acquisition and termination of citizenship in India are contained in the Citizenship Act 1955. Citizenship of India can be acquired by birth, descent, registration, naturalization, incorporation of territory, termination, renunciation, acquisition of another country, deprivation. So citizenship of India can be acquired by birth, descent, registration, naturalization, incorporation of territory, termination, renunciation, acquisition of another country, deprivation. Now citizenship by birth. Citizenship we will see one by one. Citizenship by birth. Every person born in India on or after 26th January 1950 is a citizen of India by birth, except if at the time of birth he possesses such immunity from suits and legal processes as is accorded to an envoy of foreign sovereign power accredited to President of India and is not a citizen of India, or his father is an enemy alien and birth occurs in a place than under occupation by the enemy. From 1st July 1987, that is the date of enforcement of Citizenship Amendment Act 1986, except as provided at 9A 9B above, every person born in India on or after 26 January 1950 but before the commencement of Act, on or after such commencement, either of whose parents a citizen in India at the time of his birth shall be a citizen of India by birth. Now citizenship by descent. A person born outside India on or after 26 January 1950 but before the commencement of Citizenship Amendment Act 1992 shall be a citizen of India by descent if his father is a citizen of India at the time of his birth, or on and after such commencement shall be a citizen of India by descent if either of his parents is a citizen of India at the time of his birth. Provided further, if either of the parents of such person referred to in clause B was citizen of India by descent only, that person is not be a citizen of India by virtue of this section unless his birth is registered at Indian consulate within 1 year of its occurrence, or the commencement of Citizenship Amendment Act 1992, whichever is later, or with the permission of central government after the expiry of the said period, or either of his parents is at the time of birth in service under a government of India. Then citizenship by registration. Subject to certain conditions and restrictions, the central government in the Ministry of Home Affairs may, on application made in this behalf, register as a citizen of India any person who is not already citizen and belongs to any of the following categories. A. Person of India origin who are ordinarily resident in India and have been so resident for 5 years immediately before making an application for registration prior to coming into force of the Citizenship Amendment Act 1986, that is 1st of July 1987. This period was 6 months. Person of Indian origin who are ordinarily resident in any country or place outside undivided India. Person who are or have been married to citizens of India and are ordinarily resident in India and have been so resident for 5 years immediately before making an application for registration. Prior to Citizenship Amendment Act 1986, the clause read women who are or have been married to citizens of India, minor children of person who are citizen of India, and person of full age and capacity who are citizens of a country specified in the first schedule of Citizenship Act 1955, Appendix 14.1. Then citizenship by naturalization, where an application is made in the prescribed manner by any person of full age and capacity who is not a citizen of country as specified in first schedule 14.1 for the grant of a certificate of a naturalization to him. The central government, if satisfied that the applicant is qualified for naturalization under the provision, if the third schedule grant to him a certificate of naturalization, provided that if the opinion of the central government, the applicant is a person who has rendered distinguished service to the cause of science, philosophy, art, literature, world peace or human progress generally, It may waive all or any of the conditions specified in 3rd Schedule of Citizenship Act 1955. The persons to whom a certificate of naturalization is granted shall, on taking a oath of allegiance in the form specified in 2nd Schedule, be a citizen of India by naturalization as from the date on which that certificate is granted. Then citizenship by incorporation of territory. If any territory becomes a part of India, the central government may, by orders notified in the official gazette, specify the person who shall be citizen of India by reasons of their connection with that territory, and those persons shall be citizen of India as from the date to be specified in order. Termination. Citizenship is terminated either by renunciation or acquisition of citizenship of another country. Then renunciation of citizenship. If any citizen of India of full age and capacity who is also a citizen of national of another country makes in prescribed manner a declaration renouncing his Indian citizenship, the declaration shall be registered by the prescribed authority, and upon such registration that person shall cease to be a citizen of India, provided that if any such declaration is made during any war in which India may be engaged, registration thereof shall be withheld until the central government otherwise directs. When a person ceases to be a citizen of India, every minor child of that person shall thereupon cease to be a citizen of India, provided that any such child may within 1 year after attaining full age make a declaration that he wishes to resume Indian citizenship and shall thereupon again become a citizen of India. For the purpose of this section, any woman who is or has been married shall be deemed to be of full age. Then coming to acquisition of citizenship of another country. Any citizen of India who by naturalization, registration or otherwise voluntarily acquires or has at any time between 26 January 1950. Then deprivation. The central government under section 10 of Indian Citizenship Act 1955 deprives any citizen of Indian citizenship if it is satisfied that registration or certification of naturalization was obtained by means of fraud, false representation or concealment of any material fact, that the citizen has shown himself by act or speech to be a disloyal or disaffected towards the Constitution of India as by law established, that the citizen has during the war in which India may be engaged unlawfully traded or communicated with an enemy, or has been engaged in or associated with any business that was to his knowledge carried on in such manner as to assist any enemy in that war, that citizen within 5 years after registration or naturalization has been sentenced in any country to imprisonment for a term of not less than 2 years, or that citizen has been ordinarily resident out of India for a continuous period of 7 years, and during that period has neither been at any time a student of any educational institution in a country outside India or in the service of Government of India or an international organization of which India is a member, not registered annually in the prescribed manner at an Indian consulate, his intention to retain his citizenship of India. The central government shall not deprive a person of citizenship unless it is satisfied that it is not conducive to the public good that person should continue to be a citizen of India.